Okay, guys. So at this point in our history, we have fought a war, the American Revolution, which ended in 1783 with the Treaty of Paris, wherein, among other things, the British grant and stop fighting, and a type of American history will begin. What will become a confederation of what will be the United States. And what I mean by that is that before the Constitution that we currently have was ratified, which that Constitution was ratified in 1789, before 1789 rolls around, the United States has a period of history, about a 6-year period of history, that historians refer to as the Confederation. And the reason why we call it the Confederation is because the Constitution that the United States had during those 6 years, from 1783 to about 1789, was a document known as the Articles of Confederation. But as we will find out, that particular document had some weaknesses and flaws for individuals like Washington and Madison, who wanted a much stronger executive and federal government. For people like Patrick Henry, the grand orator who said, "Give me liberty or give me death," as well as someone like Thomas Jefferson, they would want more of a limited government, and in fact were more than fine with the Articles of Confederation. Okay, but I want to start this lecture off by looking at that brief period of Confederation, and I'm predominantly going to be speaking about the Articles of Confederation itself. There definitely were some things that were accomplished during that period with respects to land policies, particularly the Northwest Ordinance. But because it's such a short-lived period, and I think it's important to eventually get to what we could rightly call the United States history, we're not going to spend a whole lot of time on the Articles, but I do think it's important to understand what they were, because there's going to be a debate over the ratification of the Constitution, where in many ways those who are in favor or like the Articles, some of the things that they express, they come right out of their love for the Articles of Confederation. And so if that statement right there is not very clear, it will eventually be cleared up as we dive in. So let's do just that. Let's move forward. Okay, so as mentioned, the first constitution of what is the United States was called the Articles of Confederation. In fact, it says here in my book, America, A Narrative History, it says, throughout most of the War of Independence, the Congress remained distrustful of executive power. And it would make sense that the Continental Congress, that many within the political spectrum of this period, that they would be distrustful of executive power, right? They had and were currently fighting a war against an executive authority, against a king who wielded all power. And what's going to happen is, starting in 1776, a plan for a type of government, which will become known as the Articles of Confederation, will be brought up by one Roger Sherman. Now, the Articles of Confederation themselves are not actually adopted until 1781. Which was the year that Yorktown came to a close, and effectively the fighting of the Revolution stopped. And so for most of the war, there is no real system of government. But what you do have is this Continental Congress that is deeply concerned and distrustful of executive power. Therefore, it assigned administrative duties to its committees and thereby imposed a painful burden on its members. At one time or another, John Adams, for instance, served on some 80 committees. In 1781, however, Congress began to set up 3 departments: Foreign Affairs, Finance, and War. Each was to have a single head responsible to Congress. Given time and stability, Congress and the department heads might have evolved into something like the parliamentary cabinet system, but as we will find, the system created under the Articles of Confederation, and as I just described, will have a number of weaknesses, and ultimately it will be replaced by the Constitution itself. Okay? But let's just understand that the Articles of Confederation were initially created during the midst of war, and what the Articles of Confederation reflect is a very strong distrust of strong federal governments. And so the principles outlined in the Articles of Confederation do not give a lot of power to the federal government. And indeed, what they do give is a lot of power to the states and the state sovereignty. Okay? It says here that under the Articles of Confederation, we took, quote-unquote, baby steps as a nation. The government conducted the affairs of the country during the last 2 years of the Revolutionary War. Indeed, no fighting occurred during those last 2 years. It negotiated the Treaty of Paris in 1783, which ended the American Revolution, and it produced two monumental pieces of legislation, which were Land Ordinances of 1785 and the Northwest Ordinance of 1787, okay, which and did a number of different things. One of the things that the Northwest Ordinance attempts to do, in fact, is to settle the issue of slavery and westward expansion, as we will see new states coming into existence. But that's not going to happen. Slavery will be allowed to extend despite the desires and wishes of those here in the Northwest Ordinance. But essentially, and the main thing I want you to get out of this is that the Articles of Confederation, because they were created to limit the amount of power that the federal government had, really made the federal government unable to do anything. Because there was such a fear of strong government, because there was such a fear of tyranny as existed under King George III, well, the founders who drafted the Articles of Confederation are now going to try and limit the amount of authority that an executive or federal government can have. And so, in many ways, the country, under the Articles, from 1783 to about 1789, it simply didn't function well because the government could not really conduct its own affairs. And we must understand that at this point in our history, it is not right to think of us as a united nation, a perpetual union, right? In fact, one of the stated objectives of the Constitution is to form a more perfect union, and we'll talk more about those terms later. But at this point, really what you have is a confederation of states who come together in a confederation, not as a union, right? People don't view themselves as Americans or U.S. citizens at this point, right? Under the Articles of Confederation, I think it's easy and correct to say that these individuals still view themselves as Bostonians or Virginians or Texans or, you know, what have you. That's how they delimit themselves, okay? And so because you don't have this strong sort of perpetual union mindset, the states don't always work together for a common good. And so because that happens, and because the federal government itself doesn't have a lot of authority, the country doesn't necessarily run very well during this brief period of Confederation. So, what were some of these weaknesses that the Articles of Confederation had? Let's go on and take a look at those. Okay, so it says here that while the U.S. Articles of Confederation was a plan of government based upon the principles fought for in the American Revolution, it contained crucial flaws. Now, what were the values of the American Revolution? That's a difficult question to answer because different people had different values. And in fact, you're going to see this played out when we talk about the development of political parties under the Washington administration, right? People like Alexander Hamilton and Thomas Jefferson, though they are both founding fathers, both they were crucial to the founding of the United States. Although I do want to state this, Jefferson had nothing to do with the building of the Constitution. He wasn't even in the country when that was being built or being written. But when you take a look at these particular two founding fathers, you're going to find out that they had very different ideas about what the country should look like. And so, you know, when we take a look at the American Revolution from Jefferson's point of view, the purpose or the values, the principles of the revolution was to create a country that had a very limited government, where the states themselves had the ability to govern themselves, where the nation would build up in type of an agrarian, small farming sort of system. By contrast, Hamilton would argue that the purpose or principles of the revolution was to create a government that would be mercantile, that would have industrial development and growth, that would have a strong economy, that the government itself would be much stronger. And so we don't want to be of this conviction that the founding fathers were all of the same mind, that they were all seeking to create the same type of country, because they simply weren't. And indeed, the flaws of the Articles of Confederation highlighted these differences. Now, what were some of these flaws or these weaknesses? Well, one, each state only had one vote in Congress, regardless of its size. So, you have a country like Rhode Island, which is super small, and a country, say, like Virginia, which is much larger. Well, each state, I know I said country, that should say state, each state only has one vote. It's not like today where in the House of Representatives, the larger the state, the more representatives you get. No, Rhode Island gets one vote, Virginia gets one vote, right? And that seems problematic because you're having an imbalanced form of representation, okay, in the government, okay? It says Congress didn't have the power to tax or to regulate foreign and interstate commerce. That's a real problem. You can't pay for things. Your economy can't grow if it can't regulate commerce, right? And while, Americans have generally hated taxation, there is a need for taxation. And because you have to have money in order to pay for things. And unfortunately, Congress didn't have the power to tax people. And so the only way that you could get money was on a volunteer basis. People had to be willing to give up some money. And this was true during the American Revolution as well. It's one of the main reasons why Washington's notion about what the principles of the revolution would actually change. He saw as he fought the war that the government was ineffective to supply the clothing, to pay for their salaries, to buy food. Why? Because there was no way to tax the people. And so during the course of the war, even Washington's notion of how large the federal government should be begins to change. There was no executive branch, which means today an executive branch would be the President of the United States. The executive branch enforces laws. So, under the Articles of Confederation, the Continental Congress could make laws, but it couldn't enforce them. That's a problem. There was no national court system. Amendments to the Articles of Confederation required a unanimous vote, right? So if you wanted to change the Articles of Confederation, you had to get all 13 states. And subsequently, if the Articles had remained in place, you would have had to have all 50 states come together and say yes or no, right? You can look at the way our Congress works today and realize that you're never going to get anyone to harmonize on one particular thing and all come to the same consensus. And so that needed to be changed. And then laws required a 9-13 majority to pass in Congress. In fact, when we see the ratification of the Constitution, you're going to see that we needed 9 out of the 13 states in order for the Constitution to in fact become law. But as we look at these weaknesses, what we find is that the government simply could not function well. It was not going to be able to govern appropriately. And this is going to raise some real problems. And in fact, people will begin to rebel. People will begin to move against the process of keeping this particular institution in place. Okay? It says, well before the outbreaks in New England, and we'll be talking about some of those, the advocates of a stronger central authority had come to demand a convention to revise the Articles of Confederation. And eventually, there would be a call to revise the Articles of Confederation, and that would become known as the Constitutional Convention. Okay? Now, before that Constitutional Convention is called, there is going to be some outbreaks in various parts of the country. One of those outbreaks is going to be a rebellion known as Shays' Rebellion. Let's move on. All right, to summarize the articles, it says each state therefore had the power to collect its own taxes, it had the power to issue its own currency, and it had the power to provide for its own militia. Each state, in effect, acted as its own sovereign. The government could not govern efficiently because of a general lack of power to compel states to honor national obligations. The government's main activity was to control foreign policy and conclude treaties, which in fact it did with the Treaty of Paris. It goes on to state here that economic credibility was a major problem because the government owed $42 million, which would be about $40 billion in today's money, once the Revolutionary War had ended, and the debt was mainly owed to American patriots who had fought the war. This financial obligation was not paid off until the early part of the 1800s. Now, ultimately, pressures are going to build up in the country because of the ineffectiveness of the Articles of Confederation. And so what I want you to do before we move on to the next section is I'm going to read you something, and then I want you to click on what it says, Shays' Rebellion. It's a short video that will give you a little bit of history about Shays' Rebellion. And Shays' Rebellion is not the only rebellion that occurred during this period, but it's the one that historians point to as sort of that climactic moment when people began to really realize that the Articles of Confederation had to go, or at least they had to be changed, because they simply were not strong enough. Okay, before you click on that though, let me read you something. It says, such developments led many of the revolutionary leaders to revise their assessment of American character. We have probably, concluded George Washington in 1786, had too good an opinion of human nature in forming our Confederation. James Madison decided that people were stretching the meaning of liberty far beyond what he and others had envisioned. He found a spirit of locality rampant in the state legislature that was destroying the aggregate interests of the community. In other words, some of these individuals, Washington and Madison among them, recognized that there was a lot of individualness going on. Each state was doing its own thing, and if there was going to be any type of union at all, the states had to work towards a more collective community. And so with understanding this failure, with looking at things like Shays' Rebellion, there's going to be a call for a change to the Articles of Confederation. Okay, so go ahead and click on that and then move on to the next slide. Okay, it says here that the apparent weaknesses of the Articles and the upset caused by Shays' Rebellion forced the Continental Congress to endorse a resolution calling for a convention with the, quote, sole and express purpose of revising the Articles of Confederation. See, what happens is that what becomes the Constitutional Convention was never intended to be a constitutional convention. Rather, what the Founding Fathers at this point initially wanted to do was to simply amend the Confederation that they were currently living under. But one of the things that's going to happen, or that's going to be pulled out of this convention, is so many questions will begin to be asked. Questions that, frankly, the Articles of Confederation were inept at dealing with. Okay? Think of it like this, and here's a metaphor. Imagine that you write an essay, you hand it in as a rough draft, and your teacher just edits it and says, there's so much wrong with this paper, you need to fix it. Okay? There comes a point in that situation where it's easier just to start over than to try to correct the problems that are already present. And that's really what happens with the Articles of Confederation. Because of its apparent and numerous weaknesses, it's simply easier to, crumple it up, throw it in the garbage can, and try and start something new. And that's what's going to happen. And that's why we're going to move from a convention to amend the Articles to a constitutional convention where a new document will be drafted. Now, they're meeting in Philadelphia, and they're going to meet throughout 1787. And immediately, George Washington is going to be named president of this convention. Now, this is actually a pretty significant thing to do because Washington is a well-respected individual from Virginia, and Virginia is a well-respected state and had been a well-respected colony. And by naming Washington the president of the convention, you're giving the convention and any document that might come out of it a type of legitimacy, right? Obviously, if the thing is written and supported by people that you don't respect, then perhaps you're going to respect the document less. That Washington oversees it and is the president of the convention gives it that sense of legitimacy. Now, not everybody that we want to be at the convention is at the convention. For example, Patrick Henry, though he was invited to come to the convention as a delegate and help to build the Constitution, he chose not to. He said that he smelled a rat. And what he means by this is he thought that the Articles were just fine. He didn't like that there was a convention being created in order to make the government more powerful. Patrick Henry was very much a states' rights individual and definitely wanted to have a smaller federal government. I suspect that had Thomas Jefferson been in the country, he probably would have gone, but I think we might have seen perhaps a smaller form of central government. But as it was, Thomas Jefferson was not in the United States at the time. He was in France. And so he would not be around to participate in the process of developing the Constitution itself. What he will do, in fact, is he will provide encyclopedias to James Madison from France, thinking that they might be helpful. The degree to which Madison, in fact, used those encyclopedias is not clear, but that's the extent of Jefferson's efforts with the Constitution. So, So we have a convention going on, and there's going to be a series of questions that we're going to now need to look at in order to understand how and why we moved from the Articles to the Constitution itself. So let's go ahead and take a look at that. Okay, so some of the questions that were raised or asked during this convention had a lot to deal with what the structure of government would look like, and ultimately, how would the people themselves be represented within this new system of government? And as we will see when we look at the Constitution here in a second, the document would eventually be broken up into 3 different bodies. You will have an executive branch, which will lay out the duties and powers of the presidency. You will have the judiciary branch, which will be the powers and duties of the judicial branch or the Supreme Court. And then you have the largest of the branches, and that's the legislative branch, and that would be Congress. Okay, but it wasn't quite clear on exactly how this government should look when the founders first began dealing with the Articles of Confederation and trying to create a new document known now as the Constitution. So there were a couple of plans that were introduced. One was called the Virginia Plan, and the other was called the New Jersey Plan. And these 2 particular plans sought to create a system for how the government should look. Okay? Now, we mainly take the Virginia Plan, although portions of the New Jersey Plan are also adopted, but it is the Virginia Plan that predominantly comes to define what our government looks like. And it was created by James Madison. Now, James Madison is regarded as the father of the Constitution, and he is for a number of reasons. One, he is the author of the Virginia Plan, which essentially laid out how the government would look. It didn't necessarily stipulate all the powers of each form of government, although he would be instrumental in that as well, but it does sort of lay the structure of the government. James Madison is also rightly regarded as the father of the Constitution because he is the one that sort of annotated all the discourses that occurred in the Constitutional Convention. And so if it had not been for James Madison, the world today would not know what was talked about within that convention because the convention was secret. Those who were in there did not want to be swayed by outside opinion. Okay, and then finally, he's regarded as the father of the Constitution because he drafted the first 10 amendments, or the Bill of Rights, that we'll look at here in a second. But back to his Virginia Plan. The Virginia Plan proposed for a separate legislature, a separate executive, and a separate judicial branch. Okay, he basically said we need to adopt Montesquieu's and Locke's notion of government, that the government should not be, one thing. And others said we should have separation of powers. And so we're going to create one branch of government that deals with making laws. That'd be the legislative branch. We will deal with one branch of the government that will deal with enforcing the law. That'll be the executive branch. And then finally, you have the judicial branch, which is interpreting the law and understanding the law, right? Which is what we do have today. James Madison went on to say, however, that the legislative branch, what we now call Congress, he said that the legislative branch should be broken up into 2 houses. Okay, it's what we call a bicameral legislature. Okay, and what that means is that you would not just have one house making and voting on laws. Instead, you would have 2 houses. Today, we have 2 houses in Congress. They are called the Congress, is what you call them both, but separately we would call them the House of Representatives and the Senate. Okay. Now, under the Virginia Plan, you would have the lower house, and that's what we now call the House of Representatives. And the lower house, according to the Virginia Plan, would have been selected by popular vote. So much like we vote for representatives today, okay, that's what James Madison said we should do for the lower house. The upper house, which we now call the Senate, under the Virginia Plan, the people at large did not vote for senators. And in fact, initially, when the Constitution was written, the people at large did not vote for senators. There was no direct election of your U.S. senators. Okay. Today we vote for senators, but that is a progressive idea that the people should have right to elect their senators. And so we amended the Constitution. I think it's Amendment 17. It's either 16 or 17. where the Constitution is changed so that people directly elected the Senate. Okay, but under the Virginia plan, the way that the Senate or the upper house would be selected would be from a committee of the lower house. So the people would elect the lower house, and then the lower house would create a committee, and the committee would select the upper house. Okay, and so for a good chunk of our history, it was the Virginia plan that prevailed, right? That's how our system of government looked. Now, the other plan was the New Jersey plan, and this said that there should only be a one-house legislature, which we obviously did not adopt, but the New Jersey plan said that the legislature should have the power to name a Supreme Court and levy taxes. And indeed, that's exactly what the Congress is able to do. They can name a Supreme Court, and they can levy taxes. Now, as we will find, the president does have a role to play in naming a Supreme Court justice, but it is up to the Congress to appoint and to affirm those whom the president offers up. Okay, so this was the initial plan. These were the types of things that people were offering up to try to figure out how the government should look. Okay, and that's well and fine. But once you adopt one of these plans, and again, we mainly adopt the Virginia plan, once you adopt these plans, you then have to ask a very important question about how will the people be represented in the legislature. In other words, how will the people be represented in the lower house and the upper house? Okay, now, so that you understand, today, the House of Representatives is based upon a state's population. So the larger the state is, the more people it has, the more representatives it gets. So for instance, California has far more representatives in the House than, say, Rhode Island, because its population is larger. In the upper house, or what we now call the Senate, every state gets 2 senators. It doesn't matter how large you are, you only get 2. Okay? Well, today we don't have much of a problem with figuring out who in our population should be represented. But in 1787, when the Constitutional Convention is going on, there is a question about how should people be counted and who should be counted. Okay? Because there is slavery, and there is a debate over whether or not slaves should be counted and therefore be represented in this Congress, in this government. Okay, so how do you deal with the question of slaves and representation in the new government? Okay, well, the obvious answer to that is abolish slavery, but that's not what the United States did. How did they address that question? Let's look at that now. Okay, if we take a look at this, and you can see it's popping up now, you can see how the Founding Fathers dealt with the issue of slavery and representation. What you're looking at here is a diagram which shows you how a compromise was struck. This compromise is known as the 3/5 compromise. Okay, so how did this debate unfold? Well, let's look at the southern states. The southern states wanted to count slaves in order to have more representation in the government. Okay, so because the Southerners had more people, because they had more slaves, they wanted slaves counted so that they could get more representatives in the upper and lower houses. Okay, but the Southerners opposed counting their slaves because the more people you had, the more taxes you had to pay. Okay, so on one hand, Southerners want slaves counted so that they get more representation. On the other hand, they don't want slaves counted because they have to pay more taxes. On the northern side, the argument is just the opposite. Northerners don't want slaves counted because it would give the South more representation, and they felt like that would be unfair. But the North did want to count slaves as people because that means that the greater tax burden would fall on the South and not the North. The way the United States came to deal with this issue was it said that we will count all slaves as 3/5 of a person. So 3/5 of slaves counted as population to determine representation, and 3/5 of slaves counted to determine taxation. It's a horrible compromise, but it is one that came to dominate the Constitution as far as African American slaves were concerned. They were not going to be regarded as full people. And you begin to see that this is a process wherein slaves begin to be understood. In fact, they already had been understood, but they begin to be legally understood as chattel. They are not human beings. We are not counting them as full human beings in this new government. Okay? It's a horrific, inhumane thing, but this is what happened. Okay? Now, there are a whole host of questions that the Founding Fathers had to address. I've just talked about a couple of those. I'm sure your textbook will address some of the others. But eventually, the Founding Fathers decide that the government that they've created is solid. And so in 1787, the delegates in Philadelphia at the Constitutional Convention will sign the Constitution. Okay? But the Constitution does not become law in 1787. Instead, you have to get 9 out of the 13 states to ratify the Constitution before it can become law. And as I've already hinted at, getting the Constitution ratified is not going to be necessarily an easy thing because there are people who oppose larger government. Men like Patrick Henry, okay, who simply say they would rather have a smaller government, okay? And so there's going to be about a year and a half or so period that will elapse between the time that the Constitution is signed in 1787 and the time it is ratified in 1789. And so what I want to do briefly is I want to take a look at two groups of people. One is known as the Federalists, the others are known as Anti-Federalists, and look briefly at the debates that occurred between these two groups of people over why the Constitution should or should not have been ratified. So let's take a look at them right now. All right, let's look first at the Federalists, okay? The Federalists, there was a number of Federalists. Indeed, one could rightly argue that anyone who was at the Constitutional Convention was indeed a Federalist because clearly they were in favor of ratifying the Constitution. But there are three really important Federalists that you need to know. One is Alexander Hamilton. He will later become Secretary of the Treasury under George Washington's administration. You will have James Madison, who will initially become a member of the House of Representatives and then later President of the United States. And then John Jay, who will help to negotiate the Jay Treaty during Washington's administration, and he will become the first Supreme Court Justice. These three men are noted as important Federalists because they will write a series of letters that become known as the Federalist Papers. And the Federalist Papers are basically explaining why the Constitution should be adopted. So it says here, led by Alexander Hamilton, the Federalists were the first political party of the United States. They supported the Constitution and attempted to convince the states to ratify it. Hamilton, along with John Jay and James Madison, anonymously published a series of essays known as the Federalist Papers under the pseudonym Publius. Now, the Federalists are actually responding to criticisms by the Anti-Federalists. The Anti-Federalists actually wrote a number of responses to the Constitution during the process when the states were trying to ratify it, making a series of arguments why the Constitution should not be ratified. And so in response to the Anti-Federalists, the Federalists, again, Madison, Hamilton, John Jay, will respond to them through these letters that we now know as the Federalist Papers. And you know, if you ever really want to know what the intent of the founders was with respects to the Constitution, I would argue read the Federalists' Papers, because that is where they are explaining why the document is necessary, okay? But they are responding to some critiques of the Anti-Federalists, which I will mention here in a second. But it says both Hamilton and Madison argued that the Constitution did not need a Bill of Rights. And they're arguing this because that's one of the main criticisms of the Anti-Federalists, that the Constitution initially did not have a Bill of Rights. It didn't specifically state what the rights of the people were, right? Instead, Madison and Hamilton and Jay would contend that the rights of the people are intrinsic within the document because the powers given to the government were limited, okay? Both Hamilton and Madison argued that the Constitution didn't need a Bill of Rights, that it would create a parchment barrier that limited the rights of the people as opposed to protecting them. However, they eventually made the concession and announced a willingness to take up the matter, which they eventually did. In fact, James Madison will eventually write a Bill of Rights and create the first 10 amendments to the Constitution in 1791. Okay, so this is briefly who the Federalists are. On the next page, there's a link to a film, and it's a very short film. It talks about the Federalists in a little bit more detail than this, so please watch that. But ultimately, in the end, the Federalists prevail, and the Constitution will be ratified. But before we get to looking at the document itself, which we're going to do cursorily, let's take a look at the Anti-Federalists. Okay, it says, in the ratification debate, the Anti-Federalists opposed to the Constitution. In other words, they were not in favor of ratifying the document. They complained that the new system threatened liberties and failed to protect individual rights. Now, let's be mindful that these individuals, the Anti-Federalists, would have been more in favor of the Articles of Confederation, a document that gave a great deal of power to the states and basically allowed for the state to act as its own sovereign entity, an entity that could tax itself, that could create its own currency. It basically acted in its own manner. And the Anti-Federalists saw the Constitution as a document that made the states secondary, that took power away from the people. Okay? It says one faction opposed the Constitution because they thought stronger government threatened the sovereignty of the state. Others argued that a new centralized government would have all the characteristics of the despotism of Great Britain they had fought so hard to remove themselves from. And still others feared that the new government threatened their personal liberties. Now, the Anti-Federalists, unfortunately, as the film will mention to you, were not as unified as the Federalists. Unlike the Federalists, the Anti-Federalists were not present at the Constitutional Convention, although they could have been. They chose not to be there. And so they are reacting more against the Constitution and really don't have as strong of arguments. You see, the Federalists had a plan for what they wanted to do, and the Anti-Federalists were simply just reacting to it. And so, to continue this discussion of the Federalists and Anti-Federalists, please click on that video. Watch that. You'll scroll down, and there's the video there. Watch that, and then let's take a look at the Constitution. Specifically, I'm going to briefly run through the Bill of Rights with you so you have an idea of what it is the Constitution guarantees you, but I will also provide a brief breakdown of how the Constitution itself is built up. So go ahead and watch that film, and then let's move on. Okay, so if you click on the word here that says the Constitution, it will actually take you to the text of the Constitution, where it will break down for you basically what the document says. And, before chasing down the rabbit hole of becoming a political science course and really diving into what this document says, I don't want to do that. I want to make sure that I just provide for you a general sense of how the document itself eventually developed. So, there are 7 articles in the Constitution, and I'm not going to go through all of them, but the first 3 are indeed the most important. Article 1 of the Constitution sets up the powers of the Congress, okay? And there are 10 sections to this particular article, and basically it establishes that there will be a 2 House legislature, again the House of Representatives or the lower house, and the Senate, which is the upper house. It talks about what some of the powers of those houses are, such as the power to declare war, such as the power to tax people, such as the power to deal with interstate commerce, such as the power to appoint a Supreme Court justice, such as a power to impeach a president, among many other powers. It also talks about what some of the minimum qualifications are for running for the House of Representatives and running for the Senate. Okay, and so again, you can click on this and read through what the document itself actually says. But one of the articles that you need to be aware of, Article 1, one of the sections that you need to be aware of within Article 1 is Section 8. And the reason for it is because in Section 8 of Article 1, it lays out the powers of Congress. In fact, it says the Congress shall have the power to, and then it lays out a bunch of laws or, abilities of the Congress. And at the very end of that particular section, section 8, it says, to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution of the United States or in the Department of Office thereof. This creates something known as the elastic clause or the necessary and proper clause. And basically what it's saying is that Congress, here's the power you have. You have the ability to make any laws which are necessary and proper to execute these laws, to make sure that you do what is being said that you're allowed to do. Well, the problem with necessary and proper is that it's very vague. And as you're going to see early on, particularly between debates between Alexander Hamilton and Thomas Jefferson, is that there are different understandings of what necessary and proper mean. Okay? And we'll be talking more about that. But Article 1 of the Constitution has 10 sections. It lays out the powers, responsibilities, requirements of Congress. It is by far the longest and indeed the most powerful branch of government if you focus only on the Constitution. Since the ratification of the Constitution, obviously the power of the presidency has been extended, oftentimes illegally. Okay? But that leads us to Article 2. Article 2 of the Constitution establishes the executive branch, and that particular article has only 4 sections. Okay? And like Article 1, it lays out the powers of the presidency. It lays out what the requirements of the presidency are, what it is you have to be. For instance, you have to be at least 35 years old to run for the presidency. That might seem young today, but in 1789, people didn't live as long, right? And it will lay out some of the powers that the president can have, such as commander-in-chief, right? So again, you can take a look at that. And then finally, you have Article 3, which has 3 sections to it, and it establishes one court known as a Supreme Court, and it lays out, again, its powers. And unlike the other branches of government, those who are nominated to the Supreme Court are there for life. The people themselves do not elect Supreme Court justices. According to the Constitution, the president would appoint a Supreme Court justice, and the Senate would then affirm the Supreme Court justice. What we find in all 3 of these articles is not just a separation of powers, but also checks and balances. Okay? There are things that the president can do that the Congress can then stop him. So, for example, the president can veto a law made by Congress, but the Congress can then override that veto if they get enough votes. Okay? The Congress can make a law that some might regard as unconstitutional, and that's where the Supreme Court would come in. Although, ironically, the Supreme Court, according to the Constitution, does not have the right to do what it namely does, which is what we call judicial review, which is to review acts of Congress to find out if they are legal. Indeed, the court granted themselves that power in the court case Marbury v. Madison. So declaring an act of Congress constitutional or unconstitutional is not in fact in the Constitution. Neither, by the way, is separation of church and state. That also is not in the Constitution. Those 2 words, judicial review and separation of church and state, are not in the Constitution. So that's just a broad overview. And then following the 7 articles in the Constitution, there are now currently 27 amendments. And so what I want to do here is just briefly run through what those amendments are with you. Okay, so let's go ahead and do that. Okay, the First Amendment says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press or the right of the people peaceably to assemble and to petition the government for redress of grievance. This is a very large and significant Bill of Rights. It basically says that there is no religious doctrine that the United States will force people to practice. This creates the freedom to be able to worship what you want or to not worship what you want. Okay? It's the Establishment and Free Exercise Clause. You can worship what you want. You don't have to worship anything. Okay? But this also grants people the freedom of speech. It grants you the right to have a press. Right? Obviously, there are some limits to what you can say at times, and there are some limits to what you can print. But for the most part, you have the right to say what you will, and you have the right to print what you will. You also have the right to assemble and protest as long as it's peaceful. And finally, one that I'm not sure people use all the time, but you have the freedom to do, is to petition the government for wrongs that it has done against you, right? And the government cannot come back at you, right? This is a significant amendment, one that I think a lot of students think is probably the most important. And indeed, it is an incredibly important amendment. So there's Amendment 1. Let's move on to Amendment 2. All right, the Second Amendment, indeed a highly contested and debatable amendment, is the right to a well-regulated militia, and the right of the people to keep and bear arms shall not be infringed. Okay, this basically means that you have the right to guns. Okay, there are multiple debates over whether or not this amendment grants people the right to like semi-automatic weapons. Right, it's a highly debatable amendment. But essentially, the Constitution says that the people have the right to have a militia and that they have the right to bear arms. Okay, this particular amendment could be understood to say that the militia has the right to bear arms. Okay, it says here, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Okay, because the word "and" doesn't appear after the word "free state," this could be defined to mean that the militia has the right to bear arms, but the people do not. But a lot of individuals suggest that this means that we have the right to a well-regulated militia and we have the right to bear arms. Of course, how we understand this amendment in 2016, 17, 18, and forward, right, is going to be a bit different than how they understood it, you know, in the 18th century. So, but that's your Second Amendment right. All right, your Third Amendment right is this, that no soldier shall in time of peace be quartered in any house without the consent of the owner. This particular amendment is probably not something that any one of you will ever have to deal with or execute. But the reason why it's here is because during the pre-Revolutionary War period, King George III, I believe it was in 1765, issued something called the Quartering Act, where British redcoats who were in the region to collect taxes were forced to live with people. And the Founding Fathers said that's not acceptable, so we're going to make it a right of the people to not have to house military personnel during a time of peace. Okay, so there you go. Let's move on. The Fourth Amendment, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. In other words, you know, the cops can't just show up to your house and seize things without a warrant. This is why when the cops show up, you must ask, you should ask, you know, where's your warrant? Which will tell you and tell the legal system exactly what it is the cops are there looking for and exactly what they are able to take, right? So you have the right to not have your property and your person be seized, searched, or taken without a warrant. And that warrant must be based upon probable cause. Okay, probable cause that something has gone wrong. Okay, if there is a warrant, then it has been issued based upon the presumption that there is probable cause, and the warrant will then allow for the cops to come in and search and seize whatever it is that they're coming to search and seize. If, for example, someone were to come into your home on what we call a fishing expedition, which means they're not quite sure what they're looking for, but they're just looking for things, that could cause a lot of problems for the judicial system, because if they were to find something, if they were to find it and seize it without a warrant, it could then be inadmissible in court, and you could find yourself being let off. But that's a right of the people to not be unreasonably searched and seized without probable cause and a warrant dictating what is to be taken and what is to be searched. Okay, let's move on. All right, Amendment 5 is a rather large one. It says, no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, okay, unless you're in the military, at which case the military has its own tribunals. But in other words, this means that, no one can just take you and accuse you of a crime and put you on trial without a grand jury having heard some evidence first to indicate that maybe there should be a trial, right? This is a protection for you. For example, maybe you've pissed somebody off and they don't like you, right? Well, if you didn't have the Fifth Amendment protection, they could accuse you of doing something wrong, and the cops just come and pick you up and hold you trial, and they present some evidence and they put you in jail or kill you, right? That's not how that works. You have the right to have a grand jury listen to evidence, and that grand jury will then say, it sounds like there's enough evidence to go forward with a criminal investigation and a criminal trial, rather, and then you can be held for a crime. But that process has to be taken first. Okay. It also says that you have the right, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. In other words, if you're convicted or not convicted of a particular crime, you cannot be held for that same crime again. Okay. Nor shall you be compelled in any criminal case. This does not account in civil cases, I don't think, but in any criminal case to be a witness against yourself. This is where you'll hear people answer or say that they claim the Fifth Amendment, right? They don't want to perjure themselves. They don't want to self-incriminate themselves, so they simply claim the Fifth Amendment. Nor shall you be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. This is what we call eminent domain. Your property can be seized, but you have to be given compensation for it. So, a lot in that particular amendment, but there you have it. Let's move on. All right, Amendment 6, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed. In other words, right, if you commit a law crime in Rhode Island and you flee to, England, they can extradite you back so that you have to go to the state where you committed the crime. But when you are held for this crime, the trial has to happen rather quickly. You can't be held in prison for 30 years and then we'll have a trial. It has to happen relatively quickly, and the jury has to be impartial. So, for example, if you're an African American in the South immediately following the Civil War and you're accused of raping a white woman and you're sent to trial and every juror on the jury is a white man, that would not be an impartial jury. That would be a skewed jury. Okay, so you have to have an impartial jury, one who's going to give you a fair trial. Okay. In addition to that, you have to be informed of the nature and cause of the accusation. So when you are being arrested, they have to tell you why you're being arrested. You also have the right to confront anyone who's accusing you of a crime. Okay. And to have compulsory process for obtaining witness in his favor. And you have the right to counsel. You have the right to a lawyer. Okay. Again, there's quite a bit in here as well. Hopefully you don't ever commit a crime and you won't ever have to worry about this, but there you go. Amendment 6. Let's move forward. All right, Amendment 7. In suits at common law where the value in controversy shall exceed $20. Again, let's remember he's writing this in 1791. The right of a trial by jury shall be preserved. So if you're suing someone for $20, you can have a trial by jury. And no fact tried by jury shall be otherwise re-examined in any other court of the United States. Okay, I highly doubt anyone falls under this for $20. But hey, if you want, go find a case where someone is suing someone for $20. Let's see if that's still happening. Let's move on. Okay, Amendment 8 says that excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted. I think that one pretty much speaks for itself, right? If you're held on bail, if you're working at the Walmart, and you work, 30 hours a week, they're probably not going to hold you for, $16 million bail. You're clearly not going to be able to afford that. And you cannot be tortured, right? That's part of the values of the American system. So, pretty basic here. Let's move on. All right, Amendment 9 says this: the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. What this means is that the Constitution has enumerated powers. It has stated certain powers to the government, and it has stated certain powers to the people. The point of Amendment 9 is to say, just because we may not have listed a certain right, it doesn't mean that people don't have that right. So, for example, in 1791, blacks and women did not have the right to vote. Yet in the 21st century, they do have the right to vote. Why? Because later on in our history, we figured out that these people do have the right to vote. Okay? And because of Amendment 9, we can now make sure that, yes, these people do have the right to vote. And just because it's not currently listed in the Constitution as them having the right to vote, they do have that, and we can make that happen. So, that's an important one. And then finally, number 10. Number 10 says the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states. In other words, the Constitution gives only a certain amount of powers to the federal government. All others will be given to the states. Okay. So those are your first 10 amendments. There are a number of others. Again, there's 27 total. But again, I think I've rambled on long enough here. Go ahead and take a look at this document a little bit further. Otherwise, go in peace, be warm and filled. May the force be with you, and live long and prosper.